when MGT-14 has to be filed by a private limited company. The filing of MGT-14 is governed by Section 117 of Companies Act 2013. It has to be filed within 30 days from the date of passing resolutions for specified matters. Penalty for not filing in time: if a company fails to file the resolution or the agreement under subsection before the expiry of the period specified under Section 403 with additional fee, the company shall be punishable with fine which shall not be less than 1 lakh rupees but which may extend to 25 lakh rupees. And every officer of the company who is in default, including liquidator of the company, if any, shall be punishable with fine which shall not be less than 50,000 rupees but which may extend to 5 lakh rupees. For following matters MGT-14 has to be filed: special resolutions. Resolutions which have been agreed by all the members of a company, but which, if not so agreed to, would not have been effective for their purpose unless they had been passed as special resolutions. Any resolution of the board of directors of a company or agreement executed by a company, relating to the appointment, reappointment or renewal of the appointment, or variation of the terms of appointment, of a managing director. Resolutions or agreements which have been agreed to by any class of members but which, if not so agreed to, would not have been effective for their purpose unless they had been passed by a specified majority or otherwise in some particular manner, and all resolutions or agreements which effectively bind such class of members though not agreed to by all those members. Resolutions requiring a company to be wound up voluntarily passed in pursuance of Section 304. Resolutions passed in pursuance of subsection of Section 179. Provided further that nothing contained in this clause shall apply to a banking company in respect of a resolution passed to grant loans, or give guarantee or provide security in respect of loans under clause of subsection of Section 179 in the ordinary course of its business, and any other resolution or agreement as may be prescribed and placed in the public domain. Instances where special resolutions have to be passed: alteration in MO for change of address, alteration on MO for change of name, alteration in object clause, alteration of articles, issue of sweat equity shares, approval of scheme for providing financial assistance for purchase of its own shares, intercompany loans and investments or guarantee or security in excess of prescribed limits, remit or give time for repayment of any debt due from a director, invest otherwise in trust securities the amount of compensation received by it as result of any merger or amalgamation. Please note that above are some of the examples where special resolutions have to be passed. It is not an exhaustive list.